2025 Adam Bojelian Memorial Talk. The theme for this year is Law as a Catalyst for Optimum Patient Care and Staff Wellbeing, Not Fear. And because this talk is deeply personal to me, I'm using notes, so apologies if I'm looking down at my notes from time to time. I'll speak for about an hour, and this talk is being recorded, but you can only see me. And then at the end of my talk, we'll switch off the recording so that we can have a free, confidential discussion about the issues raised. So this talk, it's held in love and memory of Adam Bojelian, who sadly died 10 years ago this month at just 15 years old, far too soon. Since his death, apart from in 2020, when the pandemic forced its cancellation, Adam Bojelian Memorial Talks have been held annually. And I'd like to extend my gratitude to everyone who supported those talks over the years, whether it's by giving the talks, chairing them, attending them, promoting them, or sharing them. And a special thank you to Leeds Horizon, who generously host us each year. I'll speak more about Adam shortly, but first I want to reflect a little bit on why these talks were started. And it really started from a conversation I had with somebody, many of you will know, Rob Webster, where despite his young age, Adam was widely recognised by senior NHS staff for his remarkable contribution to healthcare, particularly in improving the support available for children and young people with complex health needs. And following his death, it was deemed essential to use these talks to highlight that everyone who contributes to the NHS matters, including young disabled patients, and not just those in senior positions. For those of you that don't know me, I'm Zoe Picton-Howell. I'm Adam's mother and the founder and one of the directors of the Adam Bojelian Foundation. I'm also a solicitor of over 30 years, specialising in healthcare law and human rights, with a particular focus on children's rights. My PhD, which I completed at Edinburgh University Law School, examined how senior paediatricians across the UK make best interest decisions, particularly at the end of life, and how they interpret the legal and ethical frameworks of those decisions. I continue to teach at Edinburgh University Medical School, and I also contribute to various expert advisory committees, research panels, and guidance drafting groups, including statutory guidance. And my professional expertise, combined with my personal experience, has profoundly shaped the insights I'll be sharing today. As some of you know, Adam was not only a beloved son, but also an extraordinarily talented writer. Due to his cerebral palsy, writing was a painstaking process for him. He had to spell out each word using a spell chart or word list, and it could take him weeks to complete a poem. Despite these challenges, his words carried a profound impact. Some of you may already be familiar with his blogs and poetry, which won multiple awards, including a Brit Writers Award when he was aged just 10, and a Gold Blue Peter Badge. At the age of 12, one of his poems, Christmas Gibbons, which tells the delightful story of the Gibbons helping Santa deliver their presents around the world on Christmas Eve, was set by a now Hollywood-based composer to music and reached #2 in the iTunes charts. The Independent on Sunday named Adam as one of the people that brought the most happiness to the UK. And the Scotsman recognised him as one of the key figures who put Edinburgh on the map this year, as we were living in Edinburgh at the time. Following Adam's death, a collection of his poems Playing with Words was published and launched at the Edinburgh Book Festival, a place he loved to visit. Copies of the book are available today, with all proceeds supporting the work of the Adam Bojelian Foundation, which promotes provides education and training in healthcare law and ethics, and promotes child literacy. A second book of powerful poems, which showcases Adam's advocacy writings, is currently being illustrated and is expected to be available later this year. As Adam grew older, particularly after we moved to Yorkshire, he became a passionate healthcare advocate. His blog, What Does Good Care Look Like?, has been described as transformative within the NHS, as has his poem Leadership. Academics frequently sought his insights, and the Royal College of Paediatrics and Child Health valued his contributions. Despite his brilliance and achievements, Adam faced immense challenges, not only due to his severe physical impairments and complex health needs, which meant he spent nearly half his life in hospitals, but also because of the way some consultants in particular dismissed him. Certain consultants refused to accept that Adam could understand language at all, let alone communicate and understand in an age-appropriate manner. This was despite overwhelming evidence, including his school reports, confirming that he was top in the class in every subject, and the fact that BBC journalists could interview him with ease on first meeting him. Curiously, it was only certain medical specialisms within paediatrics that questioned Adam's abilities. Nurses, consultants with more relevant specialisms, allied health professionals, GPs, dentists, teachers, shop staff, cafe workers, journalists, and even authors he met for the first time at the Edinburgh Book Festival never had any difficulty communicating with Adam. Adam experienced the NHS in all its forms: specialist children's hospitals, tertiary care centres, district hospitals, intensive care units, high dependency units, general and specialist wards. He saw the very best of the NHS, but also, sadly, at times the very worst. As Adam's mother, I witnessed it all, not only as a parent, but inevitably as a lawyer specialising in children's healthcare law. At the very same time, through my research, I was discussing best practice with senior paediatricians across the country and helping to shape the very guidelines that should have governed Adam's care. I observed firsthand the interactions between staff and Adam, between staff and me, between staff and my husband Paul, and between staff themselves. These experiences, both inspiring and at times deeply troubling, form the foundation of what I'll share with you today. I'll begin by sharing key insights from my research with paediatricians and demonstrate how these findings resonate with wider healthcare practice and Adam's experiences. I'll then use examples from statutes vital to healthcare to illustrate how the law should not be feared, but rather embraced as a vital tool to ensure optimum patient care, enhance staff well-being, and reduce fear of litigation. I'm aware that some of what I will say will be seen as controversial. However, as Adam's mother, as a lawyer, an academic, and a healthcare educator, and as someone who's worked closely with health professionals on numerous committees, I can say with certainty, fear of the law is real and widespread among UK health professionals. This fear is deeply harmful, not just to patients, but also to health professionals and to families and carers. It leads to a breakdown in communication and trust, particularly in cases involving complex and long-term health needs. However, from my perspective as a lawyer, and based on countless discussions with healthcare professionals, I believe this fear is misplaced. The misunderstanding is not just about legal technicalities in specific situations. It's a fundamental misunderstanding of what law actually is. Before I go any further, I'd like you to take a moment for you to reflect. I've provided some pens and paper around the table So please take a few moments just to write down 2 or 3 words that come to mind when you hear the word law. So from my research and my discussions with health professionals, it seems that law is seen as a rigid set of rules and restrictions far too often. Something that looms over practice like a sword of Damocles, ready to strike if they step out of line. At best, they see it as a shield, protecting them from lawsuits or criminal liability. As one consultant in my study put it, it's kind of a last resort when you're desperate. It feels defensive. If the court has decided, it takes responsibility off you. Nobody's going to charge you with manslaughter or murder the next day. So for us, it's kind of protection, but I think it would generally be much better if we didn't have to go there. As a result, law is often perceived as something relevant only when things go wrong, a tool for self-defense or for patients or families to get their own back or seek compensation. This, in my view, is a fundamental misunderstanding, one that leads to poorer healthcare, worse patient outcomes, damaged relationships, and increased stress for professionals. A more accurate perspective is that law is not about rigid rules, it's about regulating relationships. Law is about good communication and listening. In fact, most legal problems in healthcare could be avoided with better communication. This may sound like an oversimplification, but my research for paediatricians demonstrates just how powerful this perspective can be. My study, which concluded in 2018, remains highly relevant today. While some promising changes were evident, particularly among junior consultants, increasing pressures on healthcare professionals may have exacerbated the challenges identified. We obviously don't have time to go into the full detail, and so a lot of what I've said is a summary and doesn't go into, it may seem a bit confusing because it is summarised. But for those who are interested in the detail, my thesis, which is called UK Paediatricians Medical Decision Making for Severely Disabled Children, a socio-legal analysis, can easily be found on Google Scholar, and the easy way to find it is just by searching under my name, Zoe Picton-Howell. And it's perhaps helpful to hear what led me to embark on my study. The first event was when Adam was in hospital in Edinburgh. He was under the care of a team of consultants, including a neurologist, a respiratory consultant, and an endocrine consultant. Despite being obviously very unwell, the respiratory consultant, who had known Adam for many years, deemed him well enough for discharge, couldn't see anything seriously wrong with him and thought he was well enough to go home. Yet both me and the nurses were deeply concerned. Acting on my concern, I left the respiratory ward and went upstairs to find Adam's neurology consultant. Within 10 minutes of Adam having been seen by the respiratory consultant, he was examined by the neurology consultant, who confirmed that Adam was critically ill and in fact needed immediate admission to paediatric intensive care. In paediatric intensive care, it was confirmed that Adam had severe pneumonia, so a respiratory condition. Thanks to that intervention, Adam received the care he needed and was he's well self and back in school within 2 weeks. I reflected on this. How could two equally experienced consultants with the same information and familiarity with Adam, who had known him for the same long period of time, reach such vastly different conclusions? The academic in me was fascinated. What factors were they assessing, as it didn't seem to be Adam? What was shaping their judgments? The second incident or incidents which led to my PhD was observing the number of times medical consultants said things which showed a misunderstanding of the law. Examples that spring to mind include when I was in the audience of a talk being given at a children's hospital, where the speaker told the health professional audience that the Human Rights Act did not apply to children. On another occasion, a very senior medical director, when we were discussing the Human Rights Act, said to me, "Oh, we choose not to follow that here." It made me realise that there was something seriously wrong in health professionals' legal education if people who should have been living the principles of the Human Rights Act in their daily life had such a fundamental misunderstanding of it. I was therefore curious to learn more about how medical consultants learnt about the law and applied it. So my research involved 33 paediatricians, and that was 10 intensivists, 9 neurologists, 2 respiratory consultants, and 12 paediatricians who were all consultants from other specialities. 9 of these doctors also participated in in-depth interviews, and it was interesting how keen the doctors were to talk to me, with many wanting the conversations to go on for 2 or 3 hours. Their qualifications spanned from the 1960s to 1998, representing all the NHS regions except Northern Ireland, Trent and Eastern. Some had also trained and worked abroad. Significantly, none had worked with Adam or me to obtain research objectivity. A key observation was that participants taking part were likely to be those with a particular interest in the subject, meaning that they were not necessarily representative of all paediatricians. However, they all routinely made end-of-life decisions for disabled children and were often in influential roles such as heads of departments, clinical leads, or members of regional or national committees, so had influences on others. An interesting observation was more doctors in my study than might statistically be expected identified as parents of disabled children. At the end of the study, I asked a whole load of demographic information, and their perspective stood out. While doctors who identified as having a disabled sibling did not show the same pattern, those who were parents of disabled children were more positive and supportive towards the parents of the children in their care. They saw greater potential in the disabled children and viewed them as potentially being more active participants in decision making. To analyse how the paediatricians engaged with the law, I applied what academics call the legal consciousness framework, which examines how people experience and interact with law in their everyday life. At that time, it identified 3 categories of legal consciousness. The first is called before the law. People who adopt this approach see the law as distant, a formal system that ensures fairness, and those in this category believe the legal system will function properly if needed. They've got a lot of faith in the law. And then there's a second classification with the law. And people within this classification, the law is viewed as a tool to be navigated and used strategically. And this classification often includes people who understand the law well, often lawyers themselves, and understand the law's complexities. And then there's a classification against the law. These are people that see the law as oppressive, unfair, and difficult to navigate, leading them to resist or avoid involvement with the law. And using the legal consciousness framework is particularly useful in healthcare because legal consciousness can be an individual approach or it can be a collective approach. And medical training itself, as you'll be aware, is a process of socialization, shaping how doctors interpret patients, but also law and ethics. And the influential legal scholar Ian Kennedy argued, doctors make legal and ethical decisions, and he argued they're not formally trained to make these decisions. So paediatricians operate in a complex legal and professional framework. This includes guidance from bodies such as the General Medical Council, the Royal College of Paediatrics and Child Health, NICE, and also jurisprudence from the English and, in the case of Scottish doctors, the Scottish courts. As NHS employees, they must also comply with, among other laws, the Human Rights Act and the relevant UN human rights treaties. Beyond legal structures, doctors are deeply embedded in medical, paediatric and NHS cultures, each with its own norms and values. Even within a single hospital, as I'm sure you're all aware, these cultures can vary significantly between wards, specialities and peer groups. Public perception often assumes uniformity in NHS care, but as one consultant in my study starkly put it, what I worry about is equity. If you show up on a Wednesday in May, you get one set of specialists. If you show up on a Thursday in April, you get a different set, and that determines your outcome. And this echoes findings from high-profile inquiries such as the Bristol Royal Infirmary inquiry conducted by Kennedy, the Mid-Staff's Francis report, or the findings of the Learning Disabilities Mortality Review programmes, all which highlight how professional culture, values and attitudes directly impact patient care and staff well-being, and something we witnessed throughout Adam's life and indeed death. Paediatricians, like all healthcare professionals, exist in a landscape shaped by overlapping cultures, some complementary, others competing. Their legal consciousness is influenced by their education, their personal experiences, their faith, their politics, their regional background. And an interesting observation on faith in my study that came out was how doctors from certain specialisms seem to share certain faiths. For example, and this wasn't something I looked into further because obviously it was more about faith than law, but for example, the intensivists all tended to be atheists, whereas the neurologists all tended to have strong religious faiths, which I found curious, and I wondered which came first, the faith or the choice of specialism. These factors shape not only how they perceive the law, but also how they apply it in practice. Before directly asking the consultants about law and ethics, I first explored how they understood certain commonly used terms and phrases, such as prognosis, futility, quality of life, and cognitive ability. I did this because a consultant's interpretation of these terms influenced how they applied the law and followed professional guidance. What I found particularly interesting was the lack of consensus amongst consultants, even for terms as fundamental as prognosis. Their definitions varied widely, including, for prognosis, trajectory of illness, severity, pain and comfort, current clinical knowledge about the condition, and perhaps unexpectedly, one consultant described prognosis as parental aspiration. Certainly when there's no agreement on what is being assessed, it's difficult to apply strict rules and regulations. There was also significant variation in how consultants weighed different factors when making end-of-life decisions. Despite coming from a relatively narrow spectrum of society and a narrow spectrum even of the medical profession, the consultants in my study demonstrated diverse perspectives on what should be considered and how much weight should be put on each factor. Some broad trends were found. Come in. Some broad trends emerge within subgroups. For example, consultants who qualified in the 1990s appeared more inclined to consider futility and a child's perceived quality of life, despite lack of consensus on what these terms mean in their best interest decisions, whereas those who had qualified decades earlier placed less emphasis on quality of life. Of all the factors, quality of life stood out for the diversity of ways it was interpreted and applied, and many of the consultants seemed to use it as a proxy for the child's best interests, drawing on a wide range of clinical and non-clinical, so welfare considerations. My study suggests that in assessing a child's best interests, consultants tended to place greater weight on non-clinical factors, such as quality of life, than on strictly clinical ones. In my study, clinical factors were defined as those based on direct observation and treatment by a health professional, whereas non-clinical factors included, according to the consultants themselves, considerations such as whether a child was happy at school or what their relationships with others were like. This brings us back to Kennedy and his concerns, which remain highly relevant here. He argued, rightly in my view, that the medical professionals often assess non-clinical factors beyond their own expertise, sometimes making prejudicial assumptions rather than consulting those with direct experience. In some cases, this includes failing to consult the patient themselves, even when appropriate. Indeed, as I mentioned at the beginning of my talk, Adam's experience illustrates the problem clearly, with paediatricians, or certain paediatricians, wrongly assuming he could not understand or communicate simply because of the extent of his physical impairment. As mentioned earlier, I was also interested in the legal and ethical education of consultants. Every clinical decision has a profound impact on a patient's rights, whether it's something as straightforward as consenting to be touched or to remain in hospital, or as complex as undergoing highly invasive surgery or facing the withholding or withdrawal of treatment, which may ultimately lead to death. Given the gravity of these decisions, a doctor's understanding of the legal and ethical implications of their daily practice is crucial. I wanted to explore with medics how they acquired this knowledge and from whom. Formal education and training in law and ethics in my study was notably lacking. Only 9 doctors, 27% of my study, reported receiving any legal or ethical education during medical school. For all but 2 of them, this education was minimal, typically a single lecture. The remaining 73% reported having received no such education at all. What's interesting is that the 2 doctors who had received more than minimal education in law and ethics had spent their undergraduate years in Scotland or mainland Europe rather than in England. The gaps in education persisted beyond medical school. 17 doctors, 52%, reported having no further training in rights, law, or ethics since qualifying. This is particularly significant given that all participants in my study are paediatricians, and the UK government has repeatedly assured the UN Committee on the Rights of the Child that all professionals working with children in the UK receive education and training on the Convention on the Rights of the Child. My findings suggest that this doesn't seem to be the case. In total, my study found that 48% of the paediatricians surveyed had received no formal training or education in law, rights or ethics at any stage, despite making daily decisions that affect their patients' rights. 3 of the doctors had sought out master's level courses in healthcare law and ethics, but their motivations were unclear and potentially different for each. Were they, as legal consciousness theory might suggest, arming themselves with the law as a sword, or protecting themselves as the law as a shield? Or were they striving to provide best possible patient care? All possible motivations. My data did indicate that more recently qualified doctors were more likely to have received education in law and ethics compared to those who had qualified earlier. This suggests that the situation may be improving, but at the time of my study, almost half of doctors responsible for best interest decisions had received no legal or ethical education. A particularly striking finding was that even when training in law and ethics was provided, it was usually delivered by a medic rather than a lawyer. And I'm aware of one medical school where it's delivered by a dentist. A common justification for this approach is that only medics can truly understand the context in which clinical decisions are made. However, in my view, this misunderstands the role of a lawyer who immerse themselves in their client's professional environment to understand the context of their decisions. The concern, as Kennedy had previously noticed, is that doctors are not trained in the law. While some complete a master's course in healthcare and ethics, this provides only limited legal expertise. To draw a comparison from my own life, when Adam was young, because he had communication difficulties, I completed a master's in alternative communication for children. But this did not furnish me with the expertise to teach others about the subject, despite the fact I was already an experienced university tutor. To draw another comparison, during Adam's life, I gained significant knowledge about epilepsy, not only from Adam's day-to-day experience, but also serving on committees such as the confidential child death review of epilepsy cases, where multiple cases were examined, and from reading relevant research papers. However, despite this knowledge, it would not be acceptable for me to teach medical professionals about epilepsy, as I'm not a trained and experienced medical doctor. And I don't think any doctor would accept clinical training from me. Likewise, it's problematic for doctors without formal or only limited legal training to be the primary educators in law and ethics. In my view, legal and ethical education from medics should be jointly delivered by both doctors and lawyers, ensuring that training benefits from expertise and perspectives of both professionals. Indeed, several doctors in my study who had received law and ethics education from other medics felt that they had been taught to be overly defensive and biased, focusing exclusively on the law as a shield, with no consideration of law from the patient's perspective or as a tool for patient advocacy. Indeed, several suggested the education they did receive increased their sense that law was something to be feared. Another key finding from my study was that consultants who had completed some legal education were often perceived by their colleagues as having far greater legal expertise than their actual level of legal education warranted. These doctors were frequently regarded as legal experts, entrusted with educating their peers on legal matters, deferred to in situations involving legal questions, and appointed as head of ethics committees. One doctor in particular, who was eager to discuss the law in great depth during their interview, was keen to demonstrate their knowledge of case law and statutes. However, from a legal perspective, much of what they cited reflected misunderstandings of the law. Despite this, they appeared to embrace the law and draw both personal and professional empowerment from their perceived expertise. They seemed to gain status and admiration from colleagues and suggested that legal knowledge provided them with authority over junior doctors, patients and families. Based on this, I proposed in my study an additional category of legal consciousness, law as kudos. I suggested that this category of legal consciousness is likely to be found among elites, those who have easy access to legal education and who already hold positions of respect and power. While studying law and ethics may provide individuals from marginalised groups with a sense of personal empowerment, unless they are formally enter the legal profession, it seems less likely that they would be able to leverage their legal knowledge to enhance their professional status in the same way. In contrast, doctors in my study who had undertaken even a relatively short course in law were ascribed significant legal expertise by their peers. And this is an example of the relational nature of legal consciousness. For while these doctors were viewed as legal authorities within the medical community, they would likely not be perceived as such by lawyers. So this raises an important question. Does legal education matter, particularly when so many doctors have had little or none at all? Do those who studied law and ethics act more lawfully or provide better patient care? The answer is perhaps counterintuitive. However, my findings may offer insights into why some doctors choose to pursue legal education, such as a master course in healthcare law and ethics. In my study, I examined whether doctors who had undertaken legal training approached end-of-life decisions differently from those who had not. I specifically asked participants about the relevance of law and ethics to their best interest decisions. Strikingly, none of the doctors explicitly mentioned best interests or a similar concept in response to the question about law, despite best interests being the central legal and ethical framework for end-of-life decision-making. Only 4 doctors, 12% of the study, had previously identified best interests as a factor in their decision-making, but the fact that they didn't mention it in relation to law suggests that perhaps they did not recognise that it's a legal construct. Notably, 60% of doctors in my study made no reference to best interests or to a similar concept such as balancing benefits and burdens at any point in their responses. Additionally, 14 doctors, 42% stated that as long as they did not break the law had no relevance to their decision making. This reflects the perception of law as something external, influencing practice only when a problem arises, rather than an intrinsic part of clinical decision-making. Overall, doctors who received legal education or training did appear to contextualise best interest decisions for disabled children differently from their colleagues who had not. However, whether this difference was a direct result of their legal training, or whether doctors with a particular decision-making approach were more likely to seek out legal training remains unclear. One striking finding was that doctors who had studied law tended to fear it more than those who had not. At the outset of this talk, I noticed that fear leads to poor patient care and negatively impacts on staff well-being. The doctors in my study, particularly those who have studied law, described precisely this fear. They reported taking steps to protect themselves, to avoid litigation, and in their words, prevent losing their licence, rather than focusing on acting in a patient's best interest. Their anxiety was severe, with some doctors describing deep moral uncertainty, sleepless nights, worrying about the legal implications of their decisions, or, confusingly from my perspective as a lawyer, saying they took decisions they knew to be wrong to avoid being sued or sanctioned by the GMC. When each doctor's decision-making is mapped to how the jurisprudence of the court says best decisions should be made, the doctors who saw themselves as having legal expertise tended to view themselves as the sole decision maker, the experts in law and medicine and the child, making decisions, in fact, contrary to how the law says that such decisions should be made. In contrast, doctors who were not overly focused on legal rules, those who did not see the law as particularly relevant to the law, were counterintuitively the ones whose decision-making aligned most closely with legal requirements. They routinely consulted widely, involved children in decisions where possible, carefully balanced benefits and burdens, and engaged in broad discussions to ensure all perspectives were considered. Several doctors in this group, whom I termed soft-liners, in contrast to the hardliner label one doctor in the legalistic group had given herself, expressed that they did not see themselves as decision makers. Instead, they saw their role as coordinators, responsible for gathering and balancing information to determine the best course of action. And this approach much more closely reflects how English law says best interest decisions for children should be made, and indeed how the Mental Capacity Act says that decisions for over 16-year-olds should be made. Indeed, ultimately, it may be misleading to speak at all about a single best interest decision. Disagreements are inevitable, and not, according to the consultants in my study, as the media portrays it between doctors and patients, but they told me that the disagreements tended to be from consultants from different specialisms, each bringing their own perspective on what was best for the child. The law does not demand the imposition of a single correct decision, but instead desires a best interest process, one that involves the broadest possible consultation to ensure all relevant information and viewpoints are considered before taking potentially irreversible steps. So this raises the important question: does teaching law to health professionals unintentionally contribute to the very fear that harms both patients and staff well-being, eroding trust rather than strengthening it? At first glance, my study might suggest that it does. However, my broader research and discussions outside of that study leads me to believe otherwise. One key observation I've made is that nurses who have studied law tend to understand and apply it much more effectively, aligning it to how the courts intend, compared not only to nurses who have not studied law, but also to doctors who have. And I've considered why this might be, and I believe this difference may be explained by the new legal consciousness classification of Laura's kudos. In the hierarchy of health professionals, consultants hold an elite status in the way that within healthcare and in society, nurses do not. Studying law may not carry the same prestige for nurses as it does for consultants, which raises the question of whether their motivation for legal education may differ. My experience suggests that when law is understood and applied correctly, it enhances both patient care and staff well-being. The key is how it is taught, not as a weapon, a sword to attack or a shield to defend, but as a practical tool to support better patient care. So let's look at some examples to understand how the law can be wrongly applied, enhancing fear, and the same example can show an example of how it can be used to improve patient care and health professional well-being. So let's take an example where we might apply the Mental Capacity Act. So my example is a 90-year-old woman with dementia who's admitted to hospital with pneumonia. She's confused and unable to understand the risks and benefits of treatment. The medical team must decide whether to administer intravenous antibiotics and whether she should stay in hospital to be treated or return home with support. So how might a medical professional who's been overly defensive act? Well, using the Mental Capacity Act, well, instead of assessing the patient's best interest carefully, they might default to the most conservative and legally safe option. They might admit the patient into hospital without fully considering whether it's the least restrictive and most appropriate approach. Because they fear being sued or investigated, they might prioritise defensive medicine over patient-centred care. They might not correctly assess the patient's capacity. They might assume that dementia automatically means that the patient lacks capacity without conducting a proper assessment under sections 2 and 3 of the Mental Capacity Act. And in fact, when I've done teaching sessions on the Mental Capacity Act, that is the most common error that I find among health professionals, that they assume that certain conditions result in a lack of capacity, which is a wrong interpretation, as we'll come to. They could also fail to recognise that capacity is decision-specific and may fluctuate, leading them to dismiss any attempts by the patient to express a preference. They may fail to consider the patient's wishes and assess their best interests properly. Out of fear of legal scrutiny, they might over-rely on a standard or safe decision rather than following the structured best interest process. In fact, that was one of the things I found with many of the doctors that had had some legal training, that they created their own rules, which they applied. So they decided if a child can't, for example, perform a certain physical action, they wouldn't allow them to be admitted to intensive care, rather than doing an individual assessment on a particular child. They may focus too much on medical opinion and fail to give enough weight to the views of the patient when that's information's available, the family and carers. And instead of weighing the least restrictive option, they may insist on hospital treatment when, for that particular patient, home care might be more appropriate. And rather than genuinely considering all the relevant factors, they might justify a decision by saying it's in the best interest without a thorough consultation. And that was a term I often heard doctors say to me, which was quite a strange situation to be in when you're doing a PhD in best interest law. But I often had doctors say to me towards the end of Adam's life, oh, it's in his best interests, and I'd ask them to expand on it, and they couldn't then expand on it. But often that's used to close down discussions. And this can lead to paternalistic decisions that overlook patient autonomy and past preferences. And they may fail to engage with the wider team. A fearful consultant might make decisions in isolation without properly involving the multidisciplinary team, family and carers, and the patient themselves, because they're afraid that consultation may lead to legal challenge. And lack of consultation risks making a decision that is legally questionable and may later be challenged. And also, somebody who's too defensive may make unnecessary court referrals, so which may cause delay, cause stress to all involved, and also costs involved. There are circumstances where a referral to court are appropriate, and that's clearly set out in the Mental Capacity Act. But obviously, when referrals to court are made inappropriately, that can lead to greater problems for all concerned. So fear of the law can lead to overly restrictive, defensive and paternalistic decisions that fail to be in the patient's best interest. But that's not what Parliament intended when they enacted the Mental Capacity Act. The Mental Capacity Act was enacted to empower individuals to make their decisions as far as possible and to be involved in decisions as far as possible. It was enacted to protect those who lacked capacity by providing a clear framework for decision making. And it was enacted to clarify who can make decisions on behalf of someone who lacks capacity and in what circumstances, and to ensure decisions are made in the person's best interest in the least restrictive manner possible, and to create safeguards to prevent abuses, including, for example, the creation of lasting powers of attorney and the Court of Protection and mental capacity advocates. So how might a health professional use the same act to enhance patient care and staff well-being? Well, using the Mental Capacity Act, sections 2 and 3, the team can assess whether the patient can understand, retain and weigh the information they're being given. They can determine, and they might determine, that the patient lacks capacity. But of course, the starting point of the Mental Capacity Act is that everybody has capacity, whereas too often the assumption is made that because somebody has a certain condition, that they lack capacity. And then, if someone does lack capacity, using section 4, the health professionals should not assume what's in the best interest, but should follow a structured best interest process. They should consult family members and ascertain the patient's wishes. They should involve the patient as far as possible. They should consider past and present wishes. They should speak to, for example, to the patient's GP or any therapists involved or social workers involved. And they should assess whether the hospital's admission is the least restrictive option. And then, referring to minimising restrictions, which is required by section 1(6) of the Mental Capacity Act, if the team decides the best approach is to treat at home with community support, then, and this aligns with the patient's prior wishes, then it will be less distressing than a hospital admission. And then they should ensure that appropriate support's in place so that care at home doesn't become a second best option, but the best option for that patient. So the support of nurses and home visits and emergency contact plans in place. And they should ensure the patient receives care tailored to the patient's best interests and ensure they don't use a one-size-fits-all approach, and that the patient's dignity, autonomy and comfort are respected. And the structure of the Mental Capacity Act ensures all relevant perspectives are considered, reducing the risk of inappropriate or distressing interventions. And let's think how all this might help the health professional. Well, first of all, this approach will reduce fear and anxiety. By following the Mental Capacity Act correctly, practitioners avoid making rushed or defensive decisions out of fear of legal repercussions. Practitioners can also be confident in their decision making. Using the best interest framework reassures practitioners that they're acting lawfully and ethically. It can also reduce conflict and stress. Consulting widely and involving family reduces disputes and complaints rather than increases them. As I said, poor communication is often what lies behind litigation, and very often you'll see that families litigate because they say they wanted to find out what really happened, whereas if there's open communication, that's not going to be a problem. And also, health professionals will have ethical satisfaction, knowing they have respected the patient's rights and dignity, and that will improve job satisfaction and emotional well-being. So we can see how applying the Mental Capacity Act, and very key to this is knowing the Mental Capacity Act code, it can be used as a tool for better patient care and ethical, legal and emotional well-being of staff as well. So now let's consider the Mental Health Act. And this is a scenario where a 35-year-old man with severe schizophrenia stops taking medication, leading to hallucinations and delusions that makes him a danger to himself and others. He refuses voluntary admission, believing the hospital staff are part of a conspiracy against him. His family and community mental health team grow increasingly concerned as his condition deteriorates. Now, if the health professionals are acting defensively, they may overuse their powers of detention just to be safe. A doctor, fearing legal repercussions, may section a patient too quickly without fully exploring the alternative options, such as community treatment. They may detain the patient under Section 3 instead of Section 2 of the Act, unnecessarily committing them for a longer period when a further assessment could suffice. And instead of seeking voluntary engagement first, they may default to detention out of fear of being blamed if something goes wrong. They may ignore the least restrictive principle in the Act. The Mental Health Act Code emphasises this least restrictive option, and a defensive clinician may ignore this, opting for the hospital detention instead of perhaps community support, out of concern that allowing someone to stay in the community could result in professional scrutiny if something untoward happens. Even within hospital, they may use seclusion or restraint more readily than needed, prioritising legal protection over patient dignity. And they may fail to consider a patient's rights. For example, their right to an independent mental health advocate and their right to appeal detention. A defensive clinician may discourage or delay access to the advocate or withhold information about the rights to an advocate and to appeal. Or they may overuse Section 5.2, which allows a doctor to hold a voluntary patient in hospital for up to 72 hours while awaiting an assessment. Or they might use it unnecessarily, fearing a scrutiny if the patient leaves. Or they may over-refer to senior colleagues or to legal teams, causing further delay. And how might the same scenario be handled in a way that enhances patient care and staff wellbeing? Well, again, it's worth looking at what Parliament intended for the Act. It was intended to ensure appropriate care and treatment for individuals with serious mental health conditions, particularly those who may not seek or accept treatment voluntarily. It's to provide legal authority for compulsory detention and treatment in specific circumstances where an individual's mental disorder possesses a risk to themselves or others. The Act's intended to safeguard patient rights by setting out clear procedures for detention, appeals and review by tribunals and independent bodies. It's intended to balance individual liberty with public protection and ensure that compulsory treatments only used when strictly necessary and proportionate. And it's intended to regulate the role of professionals such as approved mental health professionals and responsible clinicians in decisions regarding detention and treatment. So, if the Act is used correctly, under Section 2, the two doctors might confirm that the patient does need hospital treatment. An approved mental health professional might agree detention is necessary for health and safety and protection of others. The immediate benefits to the patient is that they access treatment and they can receive appropriate medication and psychological support, improving symptoms. and they should hopefully get a structured care plan, and the clinical team can assess the condition, stabilising the patient, and plan for long-term care. And their rights should be protected with the use of the legal safeguards, like the appeals and the independent reviews which the Act provides. So how might this help staff well-being? Well, again, moral distress should be reduced. Healthcare staff often experience ethical dilemmas when a patient refuses treatment. But the Act provides a clear legal framework ensuring decisions are made lawfully and ethically. It enhances staff safety because staff can intervene before a crisis escalates, reducing the risk of violence or self-harm to the patient, which causes trauma to both patients and the healthcare team. The Act supports a collaborative approach with multi-professional involvement, which means that staff are supported in their decisions, which reduces fear of legal repercussions. And it adds to long-term satisfaction. Seeing patients recover and regain stability reinforces a sense of purpose and fulfillment and helps prevent burnout. And lastly, we'll look at an example from the Human Rights Act and how that can be used correctly or incorrectly. So in this example, it's an elderly patient with advanced motor neuron disease. And the patient has lost the ability to communicate verbally and is nearing the end of their life. Now, this patient has expressed through previous written statements and communication aids that he doesn't want invasive life-prolonging treatment such as mechanical ventilation. However, the patient's family disagree and insist that all possible interventions should be pursued. So the medical team feels conflicted about whether to continue treatment in the patient and whether that's in the patient's best interest. So professionals acting in fear of the law may fear legal action from the family, and so it may lead the family to override the patient's wishes and give treatment that the patient has made clear they would not want. And this would disrespect the patient's right to autonomy and bodily integrity under Article 8 of the European Convention. And it would also unnecessarily prolong the suffering that the patient is feeling, which would be a breach of Article 3 of the Convention. The doctors may fear that they'd be accused of negligence if they don't take the action the family want. But the European Court of Human Rights has made clear that subjecting patients to treatment they find degrading or distressing is a breach or can be a breach of Article 3. And failing to act due to fear from colleagues or family backlash might violate Article 2, the right to life. And Article 2 might be misinterpreted as a duty to always keep someone alive, although again, the court has made clear that in appropriate circumstances, the appropriate withdrawal of care is not a breach of Article 2. Or again, they may inappropriately take time by applying to court, causing delays and prolonging suffering and causing stress and financial hardships for all involved. And the patient's voice may be lost in the decision making, again a breach of the patient's right to personal autonomy under Article 8. And a patient with disability has a right under Article 14 to be treated, not to be discriminated in their article rights because of their disability. So, you know, if patients treat disabled patients differently because of their disability, they could be breaching their Article 14 rights. So how, in contrast, could the Human Rights Act be used to provide better care? So Article 8, the patient's autonomy, dignity and rights to make decisions about their own body and treatment can be ensured. So the clinicians can respect the patient's previously expressed wishes and ensure treatment decisions align with what the patient would have wanted. Article 3, prohibition on inhumane and degrading treatment, prevents unnecessary suffering and guides doctors to make clinically and ethically sound decisions, balancing the duty to preserve life with the duty to prevent suffering. And again, of course, Article 14 applies. And how does this improve health professionals' well-being? Well, again, it reduces ethical distress. The legal clarity provided by the Human Rights Act ensures the health team do not feel pressured to administer inappropriate care, but to give appropriate care. It prevents conflict, whether with families or with colleagues, by grounding decisions in human rights law. And health professionals can explain that they are following legal and ethical frameworks rather than making arbitrary decisions. It enhances job satisfaction, knowing that they're acting in the patient's best interests and respecting their dignity, reinforcing a sense of professional integrity and well-being. And it provides legal protection. Health professionals can feel reassured that their decisions are legally defensible, reducing fear of litigation. So this brings us back to the key question: does teaching law to health professionals cause harm? And in my view, the answer is not the teaching itself, but how the law is framed within that teaching. If taught as a rigid set of risks to avoid, it fuels defensive practice, anxiety, and mistrust. But if we shift the focus to law as a supportive framework, as the regulation of relationships, encouraging good communication, one that guides ethical, patient-centered care, then it becomes a powerful ally rather than a burden. When health professionals receive proper legal education, they make confident, patient-centered decisions without unnecessary fear. They respect patient rights rather than practicing defensively. They feel less anxious about legal repercussions, improving job satisfaction. They reduce conflict and unnecessary court involvement, and they're confident enough to challenge misinformation and resist pressure from others, whether that's colleagues or families or patients, who misunderstand the law. So one way to achieve this is ensuring that legal education for health professionals is delivered collaboratively with lawyers who have expertise in healthcare, and many argue also including patients with expertise in their care. By working together, clinicians and legal experts can bridge the gap between law and practice, fostering confidence, clarity, and compassionate care. The challenge then is not whether we should teach law to healthcare professionals, but how we ensure they learn it in a way that truly supports both them and their patients. Thank you.